States. In the report, we have epitomized and summarized the content of the submissions that we have received. And we also set out our recommendations, which has been endorsed by the Law Reform Commissions. And also, we have included in the final report a draft bill, which basically crystallized the wide array of recommendations that we are making, so that the reader would, at a glance, know the remit and the scope of the law reform that we are recommending. I would, however, emphasize that the draft bill itself is not final, of course, and it is just a tool for readers to focus on the recommendations that we are making in respect of this topic. By way of background, most of you perhaps would know that in personal injury cases, the court would approach the quantification of damages and arrived at a conventional lump sum award. And in many of the cases involving injury to the claimants, we call it the plaintiff, there would be a quantification of the post-accident future loss of the injured person. And in arriving at the future loss, and to crystallize it into a lump sum, the court tend to apply a multiplier and multiplicand approach. To put it simply, whether it is a head of damage by way of a loss of earnings, or whether it is a head of damage by way of medical expenses, the court would arrive at a multiplicand, that is a fixed sum for a year, and then multiply it by what is called a multiplier to arrive at a sum for that particular head of damage, and then eventually all the heads of damage will be added together to arrive at a lump sum. Now this method of calculation is by definition arrived at by way of a little bit of guesswork, albeit it is an informed guessing by looking at the evidence carefully, including expert reports and the rest. But then again, we don't have a crystal ball, and therefore, time and again, the award arrived at is criticized as being imprecise or unscientific. But one would have to accept the fact that we cannot tell what the future holds. And therefore, the court can only do its best on the basis of the evidence and adopting accepted method that is derived from many, many years of case law. One legal principle that is at the core of this exercise is that in awarding damages, the court will strive at providing full compensation for the injured person to the best that money can do. And in a Latin phrase, it is known as restitutio in integrum, meaning that to compensate the victim in full as far as money can do. The problem with a lump sum award is that there's only one certainty, is that it is either too high or too low. One can never be precise. And therefore, insofar as this principle of restitutio in integrum is to be applied, at least as an aspiration for the court to arrive at, a lump sum award is never going to be able to minimize the risk of undercompensation or overcompensation because of the various risk factors that cannot be totally eradicated. From the point of view of the victims or the claimant, the risk factors obviously would include the uncertainty of life expectancy. That is an inherent risk that one can only assess on the basis of statistical evidence. But statistics is statistics. It has own limitations. And the other risk factor facing the claimant or the injured person is that he is supposed to invest the lump sum award and to obtain return on investment so as to pay for all his medical expenses or his family expenses which he had lost because of the injury. And we all know that the financial market and the interest rate fluctuation is something that we can never control. And therefore, that would affect the rate of return on investment. And that has a direct relationship with what I said to be the discount rate in the report. Because of accelerated payment in receiving a lump sum, and because the injured person receiving the damages is supposed to invest the lump sum to get the return. If the award is calculated without taking into account the return on investment, then the claimant would be overcompensated. And therefore, setting of the discount rate on the basis of the assumed rate of return on investment is a very important consideration. And that brings to us the question as to whether or not an authority should be set up to review the discount rate, the rate of return affecting the discount rate in calculation of damages in a more effective manner, so as to avoid having individual litigants having to abuse expert evidence, in particular actuarial evidence, in order to arrive at or to argue for a particular rate of return and hence in a particular discount rate in the calculation of damages. So that's basically the remit and the background of this topic of study, which culminated in the report that is now in front of you. In the report, we have set out in Annex A at the back the respondents to our consultation exercise, and they came from a wide array of organizations, different walks of life. Those respondents include members of the legal profession, the insurance industry, labor right groups, consumer right groups, economic and finance institutions, the actuarial profession, and so on and so forth. I would, at this stage, highlight for you the gist of our recommendation, which you will find in Chapter 6 of the final report. In the main, recommendation 1, we would recommend that the court be invested with the power to order periodical payment in respect of damages for future pecuniary loss in personal injury cases. I emphasize the scope of PPO being limited to future pecuniary loss. That is mainly a reference to cost of future care and accommodations, because those expenses are directly related to the uncertainty of life expectancy. Life expectancy being unpredictable, periodical payment would do away the risks of the victim outliving the life expectancy on which the award damages was arrived at. And in making this recommendation, we emphasize that it does not detract from the free will decision of individual claimants to arrive at settlement terms as they wish with the defendant or the paying party. Recommendation 2, we recommend that the Financial Secretary be appointed as the authority for fixing and reviewing the discount rate. And in a way, that is a study by the authority headed by the Financial Secretary to look at various portfolio of investment and to arrive at a decision as to where to set the rate of return and hence how the discount rate can be assessed in quantifying personal injury damages. And in the design of the working of the authority, we recommend that the Financial Secretary should consult some panel of experts, including experts from the actuarial, from investment, from consumer rights, and so on and so forth. We have set it all out in the report as to the process of the consultation exercise in order that a determination can be made by the Financial Secretary from time to time in deciding the rate of return. That is dealt with in Part 2 of the draft bill at the end in Annex 2 of the final report. It must be emphasized that the design of this authority in setting the rate of return for computation of personal injury damage is to be applied across the board to all personal injury cases at all levels of court, and therefore there will be uniformity. Recommendation 3, we recommend that the power of the court to award PPO should be irrespective of the consent of the parties. That is a recommendation that we made from the experience from other jurisdictions as to the effectiveness of the PPO, which would require the overriding power of the court, irrespective of consent of the parties. Of course, we should separate future pecuniary loss by way of care and accommodation from loss of future earnings, because some claimant may want to have loss of future earnings to be compensated by way of a lump sum. And in the draft bill, you will see that in Clause 11, we have provided for a slight different treatment between future cost of care and loss of earning. Loss of earning can only be included if the party consent to be included in a PPO, whereas the court's compulsory power without consent of the party is only in respect of cost of future care and accommodation. And there are concerns about the extra costs and the proportionality of the cost and the trouble in introducing PPO. And in light of that, we recommend that the power of the court for granting a PPO should be limited to catastrophic cases. Catastrophic cases means injury which is of the utmost seriousness. And in general terms, we are talking about brain damage cases. We are talking about spinal cord injury, paraplegic or tetraplegic cases. Those are the cases which attract a high level of compensation. And it is those type of cases which would entail the risk of uncertainty of the claimant being undercompensated if he is to outlive his life expectancy, or if the fluctuation of the financial market is that he would not be able to achieve the rate of return in order to pay for all his expenses. Recommendation 4, we suggests that the PPO made by the court should be subject to an order, if appropriate, that upon application of the party, in the event of any serious deterioration or significant improvement of the claimant in some future date, that an application can be made to the court to vary the amount of periodical payment. And this is not something that we think would unduly add to the lack of finality of a PPO. But that is to cater for the very realistic possibility that there may be a risk of the claimant or injured person developing serious deterioration, or on the other hand, achieve significant improvement, so that there's justification to adjust the amount of periodical payment for the remainder term of the paying period. But of course, we are acutely aware of the need to put this type of application under control. And that's why you will see that in clause 21 of the draft bill, we suggested that the application be limited to one. One meaning that there can only be one application for variation. But of course, due to change in circumstances, the time for the application may need to be varied, and there are provisions for extension of time to make the application. But otherwise, the applicant is supposed to apply within the time provided in the original PPO in making an application for variation. And in recommendation 5 and 6, this ties in with what I said earlier as to what a PPO may include. I have mentioned future pecuniary loss, and future pecuniary loss mainly consists of two aspects. One is the future cost of care and accommodation, and two, it can include loss of future earnings if the parties agree to include loss of future earnings. But in the event of loss of future earnings, there is a possibility that if the recipient of PPO payment die early or prematurely, then if the award includes an element of loss of earnings, his dependents will suffer loss of dependency in the event of his premature or early death, by which stage he would cease to receive any periodical payments, and the dependents may be losing out. So we provide for an opportunity, what we call a last opportunity, for the dependents of the recipient of PPO to make a claim against the defendant for loss of dependency, which basically represent the loss of earning which has not been accounted for by the periodical payment that the injured person received lifetime. So that's the residual element of claim by way of loss of future earnings stroke dependency of the dependents. And you will see that in the draft bill, we have provided for a mechanism whereby the family members claiming for loss of dependency under these provisions would have to account for the loss of earning which the injured person has received by way of PPO during his lifetime. And we also recommend that the court's power to order what is called provisional damage. You read about it in Order 37 of the rules of the High Court, in that in the conventional lump sum situation, if there is a case in which the plaintiff suffer injury, but some of the injury has not yet manifest itself, and it is known that there's a risk at a certain period of time this injury may manifest itself, then the court can order provisional damages, assuming that the injury has not occurred, and to make an award on a provisional basis and provide for a mechanism for the claimant to apply for further damages within a specified period of time if the injury is to manifest itself and therefore the risk is materialized. That is in our current civil procedure, and we see no reason to abolish it because it serves a slightly different purpose. The major difference, if I may say, between a PPO variation order and the provisional damage is that, as I mentioned earlier, the PPO variation order can cater for either serious deterioration or significant improvement, whereas in the current regime of provisional damage, there can only be an application for deterioration, not improvement. So the PPO cut both ways. It may be for the benefit of the paying party as well, if there is a prospect of significant improvement. Recommendation 7, we recommend that the court should have a discretion to make PPO after taking into account the security of payment to ensure the continuity of payment and satisfying itself that the PPO is able to secure the full scope of the plaintiff's award. The details of our thinking has been reflected in the final report, of course. It is not the topic that we can come to a final conclusion as to the mode of funding of PPO. But one thing that's important is that we highlight the fact that the court would not likely grant a PPO unless the court is satisfied that the PPO, the payment under PPO, would be secure by a scheme. And as to the details of the scheme, we have set out various options in Chapter 5 of the report, and I believe you would be able to read about it at your own time. And we recommend that the power given to the court to order PPO be introduced by way of legislation as soon as possible, and further refinement can be made along the way after implementation when the stakeholders are ready for PPO. In the main, the stakeholder, of course, includes various classes of paying party, including the insurers, including, for instance, organization like the hospital authority, the Motor Insurance Bureau, and some other potential paying party who may be required to make substantial payment for catastrophic injury cases. The report itself is divided into 6 chapters. After the preface, you will realize that Chapter 1 is on the need and the justification for PPO. Chapter 2 deals with the review mechanism of the rate of return. And Chapter 3 deals with the limits of PPO, limiting it to catastrophic cases, for instance. Chapter 4 deals with the various situations where a PPO can be varied, and also the last opportunity for claiming loss of dependency in the event of premature death of a recipient of PPO, and also preserving the mechanism for provisional damages. Chapter 5 deals with the security consideration and the various mode of administration of PPO schemes in terms of payment and funding, of course. Chapter 6 is a summary of all the recommendations as I have foreshadowed earlier. And you will find that Annex 1 is the list of respondents to the consultation. And Annex 2 bears specific mention because that is the draft bill that encapsulate all the recommendations that we have made along the way of the final report in the various chapters. Annex 3 is an overview of the existing compensation scheme in Hong Kong. The significance of Annex 3 is that one of the options that we recommend is to harmonize the various scheme of compensation in Hong Kong, which basically ensure that the claimants will be paid regardless of any event of insolvency of insurer. And in circumstances where there's a lack of insurance cover, because for instance, the motor vehicle owner did not take out insurance, or the employer of a certain injured person did not take out employee compensation insurance. So these are all very complex situations. And at a glance in Annex 3, you will have an idea that across the landscape in Hong Kong, what do we have at the moment that may be relevant to our consideration of funding and harmonization of the system to provide for PPO. Ladies and gentlemen, that's my introduction of the final report, and my colleague and myself would be happy to entertain questions.
Okay, thank you, Mr. Chairman. 係，我哋而家嚟到答問時間啦，歡迎大家對今日發表呢個報告書提問嘅。咁有問題嘅麻煩請舉舉手，同埋講講你係邊一間嘅傳媒機構嘅。係。好，係咪 RTHK？
Yeah, two questions from RTHK. So first of all, in Section 3B, it said the power of the court to award the payment should be limited to catastrophic cases. Can you define that a little bit for us? And the second question is about 4B, where it says the review should be restricted only to one application. So does it mean that there's only one time for the review, and why is that? And if so, why is that?
Thank you for the question. For catastrophic injury, if you go to Annex 2 at page 94 of the report, catastrophic injury is in fact defined. And it means a personal injury which is of such severity that it results in a permanent disability to the person, requiring the person to receive long-term care and assistance in all activities of daily living or a substantial part thereof. And we draw attention to the current categorization of injury in personal injury cases, namely gross disability and disaster category. The reason why is that in this catastrophic injury term is drawn from the experience of the Irish jurisdiction, Lee Ting Lam, which is way back. We have categorized the injury into 4 different levels, and catastrophic injury would be equivalent to gross disability and disaster, which I think translate into, in practical terms, as I described earlier, serious brain injury case leading to loss of ability to take care of oneself in the activities of daily living, and also paraplegic or tetraplegic cases. So that is quite well known in the jurisprudence in Hong Kong, and it is a topic that legal practitioners in Hong Kong would be very familiar with. And insofar as your second question about variation for one time is concerned, if I may draw attention to Part 3 of the draft bill, which is periodical payment. And when you talk about variation, I want to introduce to you one more concept, which is called step payment. If you look at clause 12 at page 101 of the report. Now there are effectively two types of situations where the amount to be paid under PPO may change. One is step payment is that, for instance, the injured person is 12 years old at the time of the award, and it is for sure that by the age of 18 he would enter university or an equivalent tertiary institution, and therefore his need for monthly expenses, or quarterly or yearly, it doesn't matter, it depends on the terms of the order, would increase. And therefore, the order itself would cater for that eventuality by specifying that by a certain year or date, the award would be increased by a certain amount. Or alternatively, there is change in station of life of the recipient of PPO, which will lead to a reduction of the expenses. Then the order can also provide for that if such event is already known at the time of granting of the PPO. One situation would be that, for instance, upon the children of a recipient of PPO, the accommodation which is provided for the whole family would be reduced. Or, for instance, if it is known that a certain member would be emigrating to somewhere else and would not be coming back in several years' time. And if such facts are known, these events can be provided for in the order itself. That is one way in which the amount payable can be varied. But that is not the type of variation that you are asking about. That type of variation is to provide for a situation which is set out in clause 16 of the draft bill, which is at page 103. This is the type of true variation order that is subject to the limit of making one application. The provision in clause 16 refers to under A, where as a result of the act or omission which give rise to the cause of action, if the claimant develops some serious disease or suffer some serious deterioration, it is to provide for a situation where the injured person's injury has not yet been fully manifest. And upon expert evidence, as after or during a certain period of time, he is at risk of developing serious disease or serious deterioration, then the court can build into the PPO a provision whereby the claimant or recipient of PPO payment can apply to court to vary. That's one situation. And as I highlighted earlier in my introduction, 16b provides for a situation is the reverse, wherein the claimant is having a chance of significant improvement in the future. And if that happens, then the amount of periodical payment should be reduced. And that can also be, if there are sufficient definitive expert evidence, that provision can be built into the PPO. And apart from that, you will see that in paragraph 19 or clause 19 on the same page. There are certain details of the variation order that is specified in the draft bill that has to be inserted into the variable order. And I will not read it verbatim, but basically the approach is that the award of the PPO will start off with an assumption that the disease deterioration or improvement will not occur, so that there is a fixed sum for the periodical payment on the assumption that it will not occur. But then the type of deterioration and improvement, if supported by expert evidence, will be spelled out so as to form the basis of the application for variation. And over the page at the top, and the order should also specify a period within which the application should be made. And of course, there may be possibility that there's more than one possible disease or deterioration. And ye provide for the procedure whereby leave of the court is required to make the variation application. Now, clause 21 is the limit of one application that you talk about. We are mindful of the need for finality as between the party, notwithstanding that, of course, the PPO will create a situation that in a remote way, the paying party and the receiving party are still related because of the obligation to make payment. But in balancing the exercise and to provide for a possibility of variation for good reason, as I have explained earlier, we adopt the scheme in the United Kingdom and under the Irish model that the application should be limited to one. Of course, there may be a situation that the manifestation of the disease takes longer. And if we have evidence of that, the relevant party can apply for an extension of time in making the application. But it does not detract from the fact that the whole scheme is designed on the basis that only one substantive application to vary can be made. So that's where the limitation of one application comes in. It will be specified in the original PPO itself, and it will be under very stringent criteria before a variation order would be granted. And alternatively, there can be a situation where the parties agree that there is such a risk of serious deterioration, and it can be built into an agreement and formulated into an order of the court. That sort of situation is provided for in clause 23 on the same page. That's by agreement rather than strictly by an order of the court. So that is the minor variation of the variation order strictly ordered by the court. The parties can by agreement provide for that as well.
好，下一位South China Morning Post。
Good afternoon, I'm from the South China Morning Post. I have a question on the distinction between the variation agreement under the PPO as well as the currently existing provisional damages arrangement. I was wondering if for a claimant who would fall under the new PPO regime, does that mean that they would not be entitled to receive the provisional damages arrangement under the existing regime, or is there a possibility of overlap? And also on, I think, clause 21, thank you very much for your explanation just now, but just hoping to confirm that, does that mean there could only be one such application during the claimant's lifetime, or does it limit the type of application to the kind of request? So for instance, if a serious deterioration occurred, the person could apply, but if later there's significant improvement, could they make another application, or is that not possible under the new arrangement? Thank you.
I'll take your second question first, since we are on the subject. The content of a variation order, as I said earlier, would be very strict. And if you look at clause 19C at the top of page 104, the order itself will specify the period during which the application can be made. So it is strict. and it's for a purpose in order not to open a floodgate. And D, you will find that the order itself has to specify the type of deterioration or the disease that we are talking about. And therefore, there's no question of other application being made on the basis of disease deterioration outside the period or not provided for in the original order itself. And by the same token, if there is to be a significant improvement, that basis of application as contemplated in this scheme has to be provided for in the order itself. And it cannot be the case that all of a sudden the paying party got wind of the fact that the plaintiff has improved. And notwithstanding that, no provision for variation has been made in and actually, if I may say so, that can also happen in conventional lump sum award, because the court can only award damages and assess damages on the basis of the evidence, in particular medical evidence, expert evidence, before the court. Is to recover from the injury in respect of which award had been granted. There is no application for variation at all. You can say that, oh, it would be unfair. Yes, I think that would be the answer, because we are only human. We can only work on the basis of a certain system. And that explained, I hope, your concern about opening the floodgate or creating different infinite number of ways in which the parties may come to court to apply for variation. It should not happen under the design of this scheme. Insofar as your second question about the difference between PPO and provisional damages, the relevant part of the report is starting at the top of page 66. Within these two pages, I hope you will find the answer when you read further. But I would highlight the fact for you that the current provisional damages scheme, in the main, it applies to conventional lump sum award, as a lot of the respondents to the consultation have sought to highlight. But the current provisional damage regime is for a very different purpose. Like I said earlier, it is in the event that there is a risk, a known risk, that within a certain period of time, the plaintiff would develop certain disease or injury, then the court would give him an award, assuming that there is no such injury, and then he has that packet of award to take home first, and wait until the end of that period to see if the risk would materialize. This type of situation, in the main, would only be applicable, for instance, for certain industrial disease, inhalation of some harmful toxic chemical. There was no immediate manifestation of symptoms, but there's a known risk or medical evidence that he is at risk of developing cancer in the lung, for instance, then this type of provisional damage award would be useful. It would be less relevant in PPO, because in PPO, the award is by way of a periodical payment, and his need would be catered for. If necessary, there can be a variation order built into it. And the need to resort to the court's power in granting provisional damages would be rare. However, the subcommittee took the view that there's no reason to disturb the current existing provisional damage regime. That's why we recommend that it should remain on the book. Actually, from our experience, for current existing situation, even without the introduction of the PPO, invocation of the power of the court to grant provisional damages is few and far between. Is actually quite rare. And as I said, it mainly caters for situations such as the industrial accident that I adumbrated to earlier.
好，下一位，有線電視，係，唔該。等一等，係。
你好啊，想問翻呢嗰個按期支付嘅話咧，其實法庭咧嗰個指令嗰個按期個期間係咪都係由法庭去決定啦？第二個咧就係話3A 嗰度咧講未來金錢損失嗰度咧就係關乎照顧費用同埋住宿費用啦。咁呢一方面會唔會同嗰個可能通脹啊或者係消費物價指數去掛鈎咧？因為我見到其實可能嗰個 draft 嗰度都有講到話有個步階式付款嘅，咁但係呢個步階式付款係咪即係法庭喺嗰個命令嗰度係一定需要有嘅咧？同埋咧另外咧就係4A 嗰度啦，就話可能都可以俾法庭覆核原本嗰個付款令嘅，咁有講到話嗰個喺個命令度咧就要定同惡化或者改善情況性質相關嘅特定準則啦。咁嗰啲準則係咪就咁法庭可以定啊？定係要問一啲專家嘅意見啊？唔該。
Right. I take against your last question first. The variation order, as I said earlier, is under very stringent conditions as set out in the original order. And I think I have brought attention to the relevant provisions in the draft bill, which is clause 19, at the bottom of page 103. So the idea is that if the court, upon the advice of the expert and on the basis of the expert evidence, after hearing the parties, decided that there is a need to provide for a variation order, very details under the provision in 19 will be set out. And it's not exhaustive because every case is different. And that's why the court would look at every situation and to provide for the need to fine-tune the mechanism. And that's why if you look at clause 11, 3H, across the page at page 100, 3H provide for any other matter the court consider appropriate. That is a catch-all provisions in catering for the possibility, for instance, that the court may, in a standard order, call for periodical medical report to update the situation, so that the defendant, the paying party, would have the peace of mind that there is nothing to trigger any application as such. But if there is any improvement, for instance, provided for in the variation order, they would know whether it is the time to make an application. And depending on the terms agreed between the party and ordered by the court, there may be periodical report so that the paying party would know the situation of the plaintiff. So I think that is the architecture of the scheme that we have contemplated as reflected in the draft bill. Now, as to your earlier question, whether or not the periodical payment would be monthly, quarterly, yearly, or half-yearly, that are all the options on the card. It depends on the needs. And to some extent, if I may say so, the ability of the receiving party to manage the amount. If no one is helping, for instance, he may be better off having monthly payment just to pay off the expenses as and when the expenses arise. And if someone who is capable of perhaps a little bit of medium-term planning, he may benefit from half-yearly payment or yearly payment. Those are all the possibilities, and that's why we are not suggesting that the cost power should be straitjacketed. If you look at clause 11, clause 11 bracket 8 at top of page 101, you will see that the award will be index linked to composite consumer price index. And that is, in fact, I would highlight the beauty of periodical payment, because it's index linked to consumer price index automatically. And that's why it would eliminate the risk of the recipient not having enough money to pay for the medical expenses or cost of accommodation or nursing or other medical expenses because of unpredictable inflation. It's inflation proof. Whereas in the case of a lump sum award, the recipient would be taking on the risk himself in the event that inflation is incredibly high. That actually would happen in situation, for instance, currently what's happening in some countries like the United Kingdom, whereas the double-digit inflation. And if someone received an award like 10 years ago, no such high rate of inflation was contemplated at the time of the award, the recipient of the award having to use the damages to sustain a living at this time would find it very difficult and in a way disheartening to be living in fear that the money will run out. That is, in fact, the major aspect of PPO, which, in our view, justify PPO being in the armory of the court in making sure that the plaintiff receive full compensation. You will also see in clause 9, bracket 9, on the same page, the periodical payment order may include provision disapplying subsection 8, meaning the composite consumer price index, or modifying the effect of subsection 8. Now that is relevant in some situation, and I'm not suggesting that someone come to argue left, right, and center of every possibility under the sun, but that is to provide for situation. For instance, you have a foreign plaintiff, and he is supposed to receive the payment and sustain a living overseas. And in that particular country, there may be situation where the Hong Kong composite consumer price index would not be sufficient to protect him against inflationary risk. And that's why the court need to have the flexibility and the power to order something different depending on the evidence. So these are all provided for in the scheme.
好，仲有冇其他嘅問題？係 RTHK。
尷尬意即係因為我哋啲即係聽眾觀眾咧都係即係可能係聽廣東話比較容易理解呢啲即係法律嘅條文啦，介唔介意即係都用中文去可能再講多次咧？即係點解頭先一開始有講到話，其實即係可能法庭係判嗰時咧，其實比較難係去掌握嗰個數額啦，可能會判多判少咗呢個概念。其實即係點解用呢一個即係定期嘅付款方式咧，係比較即係容易去處理啦，同埋即係見到咧，其實例如喺呢份即係 summary 嗰度咧，都有講到話即係可能咧嗰個即係叫做係受益人啦，其實可能會即係如果用咗呢個按期付款之後咧，其實係可以避免佢哋俾家人咧用晒佢哋啲資產。呢一個係咪都比較係即係用呢個按期付款令嘅其中一個原意咯？另外第三個咧就係關於話嗰啲。大多數需要作出按期付款令嗰啲人咧，都需要持續嘅醫療照顧嗰啲災難性個案，可唔可以介唔介意喺呢方面咧都解釋少少？其實係咪好多呢啲咁嘅 case 咧，其實都需要長期照顧啦，咁所以即係如果用呢一個方式咧，係比較容易去處理呢啲即係長期個案，同埋點樣去即係邊啲個案可能比較係適合用呢一種模式介唔介意都介紹下嗰個即係嚴重殘疾同埋災難呢啲嘅界別啊咁樣。
好，我盡量用中文。咁其實咧頭先幾位嘅提問咧都有涉及到你問嗰個問題嘅。咁或者咧我再重申一次啦。其實你第一個問題同第三個問題係相關嘅，我會一齊答。就係點解我哋會建議用呢個 PPO 同埋呢啲 PPO 嘅人士啊？佢哋係咪通常咧都係一啲咧係有非常之嚴重嘅受傷嘅情況先至會適合咧？因為佢哋多數涉及一啲咧係需要醫療照顧啊，或者咧係一啲其他嘅協助，例如一啲間屋會唔夠大啊，嗰個PPO 咧就會係包括埋佢哋每個月租一個大啲嘅地方同屋企人住啊咁之類。咁或者你睇翻如果中文嗰個附件2咧，就會係喺第96頁啊。呢個災難性嘅傷害咧就有喺呢度定嘅。咁就係如果中文嚟講咧，就係指人身傷害其嚴重程度為導致受傷者永久殘疾，以致該人在日常生活的全部或重大部分的活動中，需接受終身照顧及協助，相當於可從法律先例辨識的嚴重殘疾及災難這兩項傷害。咁我頭先都介紹過咧，就係呢啲詞彙咧，就係喺一啲案例嗰度找出嚟嘅。咁點解我哋要喺呢個草稿嘅文件度咧係用咗災難性傷害咧？就由於因為有其他嘅國家，例如愛爾蘭，佢係用即係我哋中文講嘅災難性傷害咁。咁我哋有見第日咧，可能我哋會有參考外國嗰啲嘅案例嘅。咁所以我哋都衡量過之後咧，我哋都係用翻呢個災難性傷害呢個詞彙。但係喺我哋自己本身嘅資料庫入邊咧，我哋嘅案例用咗幾十年咧，都係分咗4個大致上啦嚇，分咗4個唔同嘅區別，唔同嚴重性嘅傷害。咁呢個災難性咧就會係相等於我哋喺案例入邊嘅嚴重殘疾同埋咧災難兩個範疇啦。咁因為咧有好多時咧要明白嗰啲嘅唔同程度嘅傷害嘅分門別類咧，佢唔係好似畫條線咁嘅。因為有啲人咧，由於佢個別身體嘅狀況，可能佢受傷肢體受傷嘅程度唔係好嚴重，但係因為佢精神上高係有特別一啲嘅殘障，咁所以佢咧引致到佢需要嘅協助同埋咧其他人嘅照顧咧就會大過好多，咁所以唔係咧將呢啲嘅唔同程度嘅傷害畫條線分咗幾格就得，唔係嘅。咁所以我哋就喺呢度特定就係我哋用呢個字話係災難性傷害，但係咧都要睇翻實際情況。我哋只係會參照翻我哋自己本港嘅案例咧，都有一啲相類似嘅分門別類嘅。咁所以最主要咧就係嗰個受傷嘅人士咧係有永久嘅殘障，同埋需要咧長期嘅照顧。至於佢日常生活裏邊任何一個細節咧，佢都係需要人哋嘅幫忙嘅。咁所以就會引致到咧佢需要定期咧就會要用一啲嘅使費咧係去支付呢啲咁樣嘅服務咯。咁點解喺呢個情況之下就 PPO 就會有好直接嘅關係同埋好處咧？就係我頭先所講咧，如果嗰筆嘅賠償金係一筆過俾嘅咧，咁如果有啲好大嘅波動嘅通脹咁樣，就好似我頭先所講，好似喺英國咁樣雙位數嘅通脹， 我諗幾年之前如果唔係因為即係世界有啲動盪咧，冇人會預期咧，突然間嗰啲通脹率係會雙位數字。咁如果有個人攞咗10年之前攞咗一筆嘅賠償金，咁佢而家要咧喺自己個賠償金嗰度咧係支付呢啲咁嘅費用咧，就會係好擔心，因為咧個通脹咁高咧，好快或者比較佢預期快咧，就會用盡咗嗰一筆嘅賠償金咯。咁所以PPO 好處咧就會係將呢啲嘅風險撇除咗。咁其他當然啦，有其他嘅風險，譬如佢可能會長命過當其時10年之前判咗嗰筆賠償金俾佢，用嚟做計數嗰個壽命啦。咁如果佢活得長咗嘅時候，咁佢就會快啲用晒啲錢就冇㗎咯喎。咁但係 PPO 就唔會有呢啲咁樣嘅風險啦。咁當然人生上高仲有其他好多講唔盡嘅風險。咁但係我哋係可以預期嗰啲咧，就喺呢個 PPO 入邊咧就會係做得到。咁同埋PPO 頭先我都介紹過，我哋有講係話，因為佢係會抗通脹㗎啦，同埋咧佢係直至到嗰個接受付款人士過身為止啦。咁所以佢理論上嚟講，佢唔應該係會擔心呢啲錢咧係會唔夠用嘅。咁所以就相比起一筆過嘅賠償金就有各種呢啲嘅好處啦。咁亦都係咧係符合翻我哋嗰個賠償嘅準則，就係如果錢有能力做得到嘅，就將佢係賠償得去到一個階段，就係佢得到全面同埋咧係合理嗰個賠償咯。咁如果你一筆過賠償咧，就點解會話一係就太高，一係太低？因為冇人準到100% 噶嘛。咁所以咧，唯一嘅肯定咧就係臨尾計數嘅時候咧，如果你睇翻轉頭，一定係太高或者太低，唔會係一定準嘅。咁當然 PPO 都唔係一定準嘅喎，不過 PPO 就會係準好多，因為佢避免咗呢啲可以避免同埋不必要嘅一啲風險帶嚟嘅後果。咁答翻你第二個問題啦，就係話點解有啲情況話喂如果好多錢俾咗一個受傷嘅人，咁佢係咪會即係俾其他家庭成員可能剝削啊，或者係有好多就係聽講就係問佢借錢啊，借咗又唔還啊之類之類。咁我哋就唔係好想有呢啲咁樣嘅情況發生。咁其實有好多嘅個別嘅例子咧，其實我哋喺行內做呢個法律工作嘅人咧，都會有曾經聽過或者經歷過有某一啲嘅案例咧。譬如有啲人其實佢根本攞咗嗰筆賠償咧，佢唔係想為自己嘅。譬如佢攤咗，工傷攤咗，咁佢可能咧就譬如攞咗1000幾萬啊、2000萬咁樣，咁佢跟住咧就好不幸地咧就有唔少嘅個案咧，係嗰個傷者係自殺。佢攞咗啲賠償之後即刻自殺，因為佢覺得佢嘅用處咧就係幫屋企人攞咗啲賠償，根本咧佢就冇意欲咧係繼續生存。咁呢啲咁嘅情況當然我哋就唔願意見到啦。咁如果係用 PPO 嘅方式咧，咁佢會可以安排佢自己嘅生活，亦都唔應該係俾佢其他嘅家庭成員係所謂有一個好似有筆錢天跌落嚟咁樣。係反為，如果係每個月或者每3個月或者每半年都啦，佢知道佢有一筆固定嘅金額入嚟，係足夠支付佢生活同埋佢嗰啲醫療費用啊各樣嘅開支咧，佢可以都有一個比較有意義嘅人生，就唔係淨係自己換用自己嗰條命嚟換咗一筆錢俾啲屋企人。咁有好多唔少嘅個案咧，就係因為親戚朋友個個都知你攞咗一大嚿錢喎，或者有個攤咗嘅案例咁樣。通常如果一個30-40歲嘅就算地盤工人啦受咗傷咁攤咗咁， 咁好簡單嚟計咧，即係普普通通咧千幾萬、2000幾萬嗰啲位都會到嘅。咁有唔少嘅情況咧，就係有啲家庭成員啊，或者屋企人話好想買樓喎，知你又攞咗嚿錢，不如借啲錢我買樓先啦咁。咁呢個咧就同我哋賠償俾呢個金額俾呢個受害人嘅目的係背道而馳。因為我哋係想個法例嚟講係想賠償佢嘅損失，以至到佢攞咗嗰筆錢嘅時候咧，真正係用於賠償俾佢嗰個目的啊嘛。咁所以呢啲就係咁講，呢啲就係一啲外圍喺一個社會嘅層面嘅考慮。但係無論點都好咧，我哋要強調一樣嘢，PPO 呢個概念咧。整體嚟講咧，係一個法律嘅概念嚟嘅，就係因為我哋有嗰個法律嘅原則，就叫 restitutio in integrum，就係賠嗰個受傷嘅人咧一個圓滿嘅賠償嘅金額。咁所以如果係一筆過嘅付款唔能夠做到呢樣嘢嘅時候，而 PPO 係會比較達到呢個目的嘅，咁我哋就會係主張法庭有呢個咁樣嘅權力。咁當然啦，呢個法庭用呢個權力嘅時候，有其他嘅帶嚟嘅後果。咁但係呢其他帶嚟嘅後果，我哋覺得嗰個考慮就比較次要啲咯。
好，仲有其他問題？明報係咪？
主席你好，我想問下可唔可以解釋一下咧個 draft 裏邊提到折扣率嗰個概念咧，對於需要賠償嘅一方咧，咁佢其實係咪好難去預測得到幾時會再俾人去覆核啦，同埋佢嗰個賠償嘅金額會唔會突然間增大咗好多？相關嗰啲準則咧，其實係咪同現時法庭考慮嘅係有好大嘅分別啦？同埋都想問究竟依家獲得賠償嘅一方咧，會唔會因為呢一個PPO， 然之後佢哋難以去提出一啲證據啦，去反駁俾人覆核嗰一方咧？即係因為佢哋覆核嘅時候都可能要考慮到一啲情況嘅改變啦，會唔會有其中一方係好難去提出一啲證據去交俾法庭去決定？唔該。
I think I'll take the discount rate question first. The discount rate is dealt with in Part 2 of the draft bill, which starts at page 96. Now, the discount rate is not unique to consideration of PPO, because as I said in the introductory part of this press briefing, because of accelerated receipt, even if the award is to be made in one lump sum, the court will have to discount the amount to account for the accelerated receipt. Because, for instance, if a worker was injured at the age of 40, and assuming that but for the injury he would work until age 65, assuming that is the case. So his working life has 25 years to run. The court, assuming that he earned $20,000 a month as a construction worker, for instance, the court in awarding damages is in loss of earning is not to multiply 20,000 by 12 months a year and times 25. That is not the method of calculation, because the assumption is that if he received the money today, he would be able to invest the money and get some return. And that's why if you multiply 20,000 in this example by 12 months in a year, by 25 years his remaining working life, he will be overcompensated. Because if he is not injured and he is working, he will only get the income every month. But you are now paying him all in one go. That's why if he invests the money, he is supposed to attain at least a few percent of return, and that means he would be overcompensated if the amount is not discounted. That's where the discount rate come into play. And historically, and by the virtue of certain case law, the conventional discount rate is set at 4 to 5%, assuming that's 4.5%. In Hong Kong, we are lucky enough that we don't have complication by tax. You can assume that the rate of return conventionally is 4 to 5%, but that has been proven to be wrong. And some of you may be acutely alive to what is called qualitative easing after the financial tsunami in 2008, which is followed by the qualitative easing policy with massive printing of money in the market, driving down interest rate to less than 1%. And if someone receives a lump sum, say in 2009, and seeking to invest it, he'll be lucky to get a return of 1%. And that's why the discount rate for the purpose of calculating their lump sum award would have a major influence on what is called the multiplier. As I said, it's not 25 years. It depends on the discount rate you apply. And it's all mathematical. And in the case that followed, called Chen Pak Ting, the court has received extremely extensive actuarial accounting evidence to decide that if it is a payment period for up to 5 years, the discount rate should only be 0.25%. And if it is up to 10 years, it's 1%, and it's over 10 years, the discount rate is 2.5%, because the longer the period of time, the more is the opportunity for the investor to recoup his investment return. But for a short period of time, there's very little time for the money to grow. And that's why, if you look at page 29 of the report, and that sets out the various rates that I've just mentioned, up to 5 years, 0.5%, minus 0.5%, not exceeding 10 years, 1%, exceeding 10 years, 2.5%. And if you look at the right-hand side column, it sets out the investment portfolio. And the assumption is based on the investment in this portfolio. And you will see that in the row exceeding 10 years, the investment portfolio is extended to fixed deposits and also bonds of BBB plus or better, and also blue chip stock that qualify as widow and orphan stock. So gradually, if you have more time, the return can perhaps be increased by engaging in a wider array of investment vehicle. It carries more risk, but it's still within range in order to arrive at that discount rate. So that's the reason why we introduce the authority to review the discount rate periodically, because in this case, the court has to receive very extensive evidence. It's very time consuming. And if the authority would take upon the exercise periodically, we recommend that the first review is to be done within 9 months of the announcement by the financial secretary. And thereafter, subsequent review will be conducted every 6 years. And although it will be announced periodically, even if there is no change. The reason why is that we anticipated that the review every 6 years would actually look at the portfolio of investments on which the assumed rate of return is to be achieved. And that is a more extensive exercise. And that's why we allow for 6 years. Insofar as the relationship between discount rate or setting of discount rate and PPO is concerned, I think to give you a very real example is that if you are an injured person and you want to decide whether to take on a PPO, you would want to know if your damage is assessed in a lump sum, what would that be, in order to see whether PPO is attractive. And that's why the discount rate in operational terms, although it is not intertwined in the concept of setting the discount rate and the PPO, conceptually they may be two things, but operationally they are closely related, because an injured person and also the defendant or the defendant's insurer as the paying party would want to know and have a assessment whether or not it would be more beneficial to have a lump sum payment or to have a periodical payment. And that is something that hinges upon the setting of the discount rate. As I explained earlier, the discount rate would dictate how the lump sum is to be arrived at. And because of the introduction of PPO, one benefit is to get rid of the risk attendant upon the variation of the discount rate. Because the periodical payment would be index linked, is inflation proof, and one doesn't have to care about the rate of return because the money would be there to meet all the expenses every month, every 3 months, every 6 months, whatever the court order on the basis of the evidence. Now, I'm seeking to draw your attention to one more terms of the draft bill in respect of periodical payment. And in the way that it is reflected in the assessment of discount rate as well. Right. Now, if you look at clause 7, bracket 3, page 98, top of 98, that's where the relationship between, an operational relationship between the determination of discount rate and PPO may come in. In setting, in the 3A, top of the page 98, 3A at the top. In making rate determination as required by subsection 2, the Financial Secretary must make the following assumption. The assumption that the relevant damage are payable in lump sum rather than under a periodical payment order. As I said, it's a comparative exercise. For setting the discount rate, you are basically setting the baseline and telling people the discount rate is set on the basis that a lump sum will be awarded, and to see what would be the rate of discount if you are paid now, assuming that you will have a stream of income by investing the lump sum today. And that's why in setting the rate of return by the authority, namely the Financial Secretary in our contemplation, the assumption is that the award of damages will be paid in a lump sum, so that applying this discount rate, you can arrive at a lump sum if the award is to be made in a lump sum, so that you can compare, can you survive on this lump sum, or are you better off in receiving the money every month, which is inflation proof, which also cater for your future change in life circumstances, whether by way of a step payment or in appropriate cases by way of a variation order in the possibility of serious deterioration. So those are the differences of the two approach and why PPO is designed to obviate the need for the claimant to take upon himself such risk.
好，時間嘅關係，最後一條問題。如果大家冇問題咧，就好多謝今日你哋嚟到我哋嘅記者會啦，同埋多謝咁多位 speaker。咁我哋今日記者會就結束啦，多謝。
Good, thank you.